Good morning, everyone, and welcome to another edition of our Justice and Peace's guest speaker series as we've been profiling and talking to lawyer and paralegal bencher candidates. Again, the views and opinions are of the candidates alone. They don't reflect me, Justice and Peace's, Charles College, or any other education institution or organization that I'm affiliated with. And this morning we are joined by Anne. First of all, Anne, thank you so much for taking the time to speak with us. Perhaps you can start by telling us a little bit more about yourself.
Thank you, John Paul. It's great to be here. I appreciate the opportunity. My name is Anne Vespry. I work in Ottawa, and I have a independent family practice. I'm a sole practitioner, and I do both negotiation-based and collaborative family law, and occasionally, when it's impossible to avoid it, I do enter into the fringes of litigation, but I'm not primarily a litigation lawyer. And I also teach. I have taught at Algonquin College, at University of Ottawa for law students, and I'm currently teaching mostly at Algonquin Academy, which is a private school where I'm teaching paralegals and law clerks. So that's my background. And one other thing, I suppose, I have been a bencher before. I was a bencher for 4 years. And then at the last election, I was not reelected. And now I'm running to see if I can do better this time.
So, Anne, and thanks for bringing that up. Right. So you've this is going to be the third time you're running, and if you're elected, it'll be the second time you're serving as a bencher. So why give it sort of the third effort here after the last election, or why are you running this time, and for the bencher position?
Because I really think that the profession deserves to have a broader set of voices in convocation. I think that the profession deserves to have people that they elect where they know who they're electing, why they're electing them. They know the individual as opposed to knowing what clique or slate or group or whatever they want to call themselves, and basically buying a bunch of individuals that have been pre-selected by some other process that is completely not transparent. There is no, we don't know, we're not told who gets chosen, who doesn't get chosen for those groups. And I think that for the sake of transparency and for the sake of actually finding people who are going to be responsible to the profession and the public and the organization of the Law Society without having their own agendas coming in. I think that that's really what will help to get convocation back on a more even keel, where instead of one group yelling at another group and nothing happening, we need to have more independent voices who can look at the choices that need to be made and make those choices without being beholden to any other group.
Now, you bring up the groups there, and certainly this election, again, seems very unique in that you have the Full Stop group, and then you have the Good Governance Coalition. And essentially, on one side, you have the Stop Bloat, Stop Creep, Stop Woke, and other similar messaging. And then on the other side, the Good Governance Coalition is like, look at that messaging. Look at what they did when the 22 Stop group was running. Slates are bad. However, vote for our group instead, because you need us to counter them. And then if we're elected, we're going to just do away with slates altogether. I mean, how does that kind of fit in with, the previous two times you were running as bencher? And I mean, maybe you could even go beyond that and think about previous elections that, is this brand new, or has this ever been kind of brought up before in terms of getting slates? And what are your thoughts on groups running together, and perhaps knowing when they get elected, having some of those loyalties still?
The first time I ran as a pretty much complete unknown. I didn't have any political connections within the lawyer community, and I would say that I probably still don't. Although I was, I believe, a good bencher, and I know that I met people that I respect in the legal governance community, and I hope that hope and expect that they respect me as well. Really, what I ran for the first time I ran was the idea that the Law Society is a completely blank organization. It puts things out, and it asks now more than it used to for input from various communities. But the process in between, a consultation and an actual decision is completely invisible. And one of the things that I promised when I first ran was to be somebody who asked good questions. Ask those: why are we doing it like this? What else have we tried? Why are we spending this money? What else have we tried? It's interesting. I find myself somewhere in between the position of the stop everything people and the governance people. I believe that there are certainly financial and decisions that the Law Society makes that are not necessarily the best, and that stopping bloat is not a bad idea at all. On the other hand, I'm not convinced by the stop woke rhetoric. I'm not convinced by the woke rhetoric either. When the Law Society brought forward their 13 proposals for improving or changing the Law Society's or the profession's attitude towards race issues, one of the big discussions was, are these 13 things monolithic, or can we vote for individual ones? Because some of them were good ideas and some of them were really bad ideas. And too often, like within the political process, I suppose, you get an omnibus piece of legislation where there's a whole bunch of good things, but then there's a whole bunch of pork barreling and really unnecessary and bad legislation tucked in the hopes that nobody will notice that while they're voting for the good things. So if we're going to prevent the Law Society from doing slates, we should prevent the Law Society from doing the equivalent of trying to stuff that sort of regulation down the throats of the voters, whether that be the benchers who are deciding in convocation, or that be the public, because essentially we have a responsibility to we as in benchers and the Law Society have a responsibility to the public to regulate, not for particular individual members of the public who scream loudest, but for the public in general, and to make the profession as beneficial to the public as possible.
Now, what are some of the issues there? And again, you're saying, look, there's points on one side, there's points on the other, and there's certainly a number of independent candidates that are running that are raising all sorts of different points. But perhaps you can tell me again, what are some of the issues in this election that you think are most important that you're highlighting?
Um, uh, I think that some of the issues have not, some of the issues will always be with us. I think that access to justice as an issue is an issue that will be um, uh, something that the Law Society has to deal with had to deal with in past elections, will have to deal with in future elections. Certainly the benchers who are elected this time around will have to have um, uh, more than just letting the Access to Justice Committee sit in its silo and do its own thing. We'll have to think about how access to justice impacts across the board, and what the Law Society can do to really improve access to justice, including things like how students are qualified, and the incredible expense that law students have to pay to get through their bar exams and qualified, and how that's an access to justice issue. We need to, excuse me, perhaps leverage some of the Law Society's influence with universities, so that there are more universities that build in alternatives to articling, that it's not just one university where you can do that and cut your costs a little bit in terms of getting into the profession. Other issues, I'm interested to see that the issue of other professions providing legal services and the ownership of legal service providers has become an issue again. It was supposed to be settled that third parties, non-licensees, were not allowed to own and operate law firms, but that seems to be coming up as a question again. And insofar as it was settled once, I hope it gets settled again and in the same direction. I don't think that I think that in terms of the profession staying as responsible as it is and as responsive as it is, we need to have lawyers in charge of lawyers and lawyers and paralegals in charge of paralegals. That third-party governance of the profession is, to me, a really bad idea.
But just continue there, because I've spoken to a couple of people who would say the opposite, right? Is that they build up this business, and when they're ready to retire, let's say if it's a very particularly niche area, then the only options they have with their book of business there is to find one of the other people that are in that area, or just let it go, right? Or wind up. Whereas if they could sell it to a third party who's not a licensee, that there may be value in that, and certainly with things like technology and leveraging technology, like we talked about AI and stuff as well, but that ownership, right? The whole like stake in a company carries more than whatever can be promised outside of that, which again is the points that they brought up. Now, again, not being an expert on this at all, maybe you can elaborate a bit more of why ownership of law firms should stay in lawyer or paralegal hands, and not even opening up the possibility to some of these things that have been suggested by other candidates.
Mainly because even though we can't always trust lawyers and paralegals to behave ethically, we wouldn't have a discipline committee if we didn't occasionally need to have people disciplined. But at the same time, we have a professional grounding in the ideas of ethical behavior. Law students and paralegal students get trained extensively in professional ethics. And certainly by the time somebody is licensed, they know their duties to the profession, they know their duties to the public, they know their duties to the courts. They are ready to be officers of the court. That idea of having corporate control, where per definition, pretty much, the role of a corporation is not to operate in the public interest. It operates in the interest of its shareholders. That's what it's supposed to do. And if it varies too far from that, the shareholders can pull it back. So having the small area open for nonprofit organizations to provide legal services was, I think, a good idea. I don't believe it's really caught on very much, but it is certainly one possibility for external management and ownership of a legal business. The idea, though, of corporate control, yes, I can see that it might be attractive to have somebody else that you could sell your firm to as part of your succession planning, but then the question is, what do they do with it? And how do they operate it? And if it's on a purely bottom line basis, then how does that work in the public interest?
Thanks for that, Ed. And I guess the other point you had brought up there, and certainly being a practitioner in family law and teaching paralegal students, and maybe you have a pulse kind of to the paralegal community about the efforts over the last 10 years to open up that area of practice, and largely, from what I hear, at least, disappointment with what the end result was last December at convocation with the FLSP. Now, I've heard, certainly talking to lawyers who may not be as knowledgeable of paralegal education and paralegal students and paralegals generally, you see things like paralegal scope should be reduced, or paralegal scope shouldn't go any further, or all sorts of things along those lines. I mean, maybe you can kind of talk about your thoughts about that, and what role do you see paralegals? I mean, first maybe in family law, but perhaps in any other areas.
I think that everybody who has doubts about the paralegal scope should take a brief moment to look at the legislation. It's our job as members of the legal profession to be aware of things like legislation and bylaws. And if you look at the legislation that was passed to create or to give the Law Society the authority to create a role for licensed paralegals, the government had in mind a vastly broader scope of practice. The government had in mind everything from family law to wills and estates to real estate, none of which have been areas that paralegals have been allowed to practice in. So we have a piece of legislation in the Law Society Act that envisions a very broad scope for paralegals. We have the Law Society, which is run by lawyers primarily, and still now is run by lawyers primarily, having put in place bylaws that hugely limit that scope, that basically don't allow paralegals to be solicitors at all. Paralegals pretty much have to practice in a barrister style. They're only allowed to do matters that involve court work or tribunal work. Do I think that the paralegal scope should be broadened? To a certain extent, yes. Do I think that the way it's being broadened is necessarily the best way forward? Not really. Do I think that paralegals have the education and ability to do work in the scope that they have currently or a broader scope? Absolutely. I have certainly huge confidence in the people that we've trained. I have confidence certainly in the people who come through the public college route, although perhaps less in certain circumstances. Bottom line, I think that the people who stay in the profession are usually very good at what they're doing. And one of the things that I think that lawyers don't understand about paralegal education, that we should understand more, is that it is not theoretical. You go to law school and you learn theory after theory after theory, and then you graduate, and if you don't have excellent articles, you have really no idea about procedural law. You don't know how to actually get things done. Whereas paralegal education teaches as much theory as necessary, and focuses on the procedural, focuses on how do you do this in practice? How do you help somebody? When somebody comes to you with a problem, what do you do? The idea of law schools having more practical education available for people who plan on practicing. The law schools will always argue, oh, lots of people take law degrees who don't plan on practicing. Fair enough. But you should have more than just, one class here or there that actually has clinic work, for instance, where people may learn something practical. The practical should be as available to law students as is the theoretical, and it's not. So if I had to choose between somebody who has been through law school, had mediocre articles, and was in their first year of practice, and somebody who had been through paralegal school and was in their first year of practice, assuming that it was an area that was within the paralegal scope, I would quite frankly have more confidence in the paralegal being able to get the job done.
Now you brought up articles there, and certainly that's been an issue as well. I don't know, again, in terms of thoughts there. I mean, over the years, and you were also talking about your time before we started here on the paralegal standing committee, or I think it was still called that at the time. But in terms of education and getting, again, from school, law school or paralegal school into the profession right after the licensing exams, and then, as you point out, well, how do you acknowledge some of those deficiencies as you get through the profession and get that experience? Anything there you can kind of add to on whatever side of the equation in terms of better preparing and getting to your fifth year of practice and thriving in there?
Well, one thing that the Law Society really needs to do, and that the profession needs to do to a certain extent, is admit that not all articles are equal. When I graduated from law school, there were people who got articles in big firms where they were going to be rotated through a variety of departments, where they were going to be paid $60,000 or $70,000 during the period of their articling, where their bar exams were paid for, and where they were likely to be hired back, and if not hired back, would be leaving with a broad cross-section of experience. I also knew people who articled for free or for on a you kill it, you eat it basis, where if they could bring a client into the firm, they would get a portion of that fee, but otherwise they were working for free, and who had very little exposure to much beyond here's the photocopier, here's how to operate it. We need this many copies of that document for this purpose, go at it. And somebody who graduates with articles like that is really not ready to provide legal services or practice law. And the way that the Law Society sets things up, the only control that there is that the articling student and the firm that they're articling with make little reports into the Law Society about whether it's going successfully. But they don't tell the students, for instance, if your articles are unsuccessful, we'll find you another place. So any student out there is thinking, if I say that my articles are not teaching me anything, I'm going to be out articles and I'll never get to practice. And this is people who have put an immense amount of money and time and effort, and perhaps even blood, sweat, and tears into getting as far as they have. They're not going to quit at that point. The reporting on articling needs to be more independent, and taking the step of making articles paid was a good idea. I supported that. Ensuring that students would get at least some wage, so that ideally the people that hire them or accept them as articling students, their principals will put them to good use, knowing that they're having to pay for it. You don't value things that are free often as much as you value something that you're paying for. And so hopefully articling students will be valued more and will get better articles in the process. As a long-term goal, I think that alternatives to articling are a good thing. So that's where I sit on that.
Now, Anna, whether on this point or any of the things that you had brought up earlier, is there anything, again, with respect to the upcoming election that you want to highlight in terms of any other issues that are important to discuss here as we get to the conclusion of our interview?
I think absolutely that transparency should be something that people are demanding, both from the Law Society and from the people who are running this venture. Transparency on what individuals stand for, what individuals believe. I will always put my email address out there. It's pretty simple. It's ann@vespry.ca. I don't think it can get easier than that. And if you have questions about what I believe in, I really encourage people to ask me. If you have questions about what shadowy powers are sponsoring my run, I can tell you none at all. I'm doing this as an independent. I think that the idea of cliques and slates and committees and communities and whatever they want to call themselves, it comes down to somebody else making choices for you. And as an independent profession, I think that we should make our own choices based on individuals, not based on some sort of mushed together group of individuals who have some sort of agenda going forward together.
The last couple of questions here. Again, you have students as well, so perhaps you're sharing these words of wisdom with them. But any words of wisdom for paralegal students, law students, so any students that are listening as they look to embark on their journey into the profession?
It really depends on the day. There are days when I would probably say, turn around and run away, as my advice. But in general, it is not always obvious, but still it is a privilege to be able to help people the way we do. We can have immense effects on other people's lives. And we need to approach that with a certain amount of humility, and recognize that even though we're the ones giving advice, we are always taking instruction from our clients. And they're the ones that know their lives best, and they're the ones that we should be listening to. I would suggest always that listening skills are probably one of the more important skills that anybody will learn and develop as a legal practitioner. We need to listen to our clients.
And finally, last question here, Anne. For any of the lawyers that are voting and have up to 40 votes to cast in the upcoming election, why should they use one of those votes on you?
Because I'm honest and open about what I believe. I am happy to give people information, or I was happy to give people information when I was a bencher. Keeping in mind whatever rules there are around secrecy, and fighting those rules while I was a bencher, because I think that benchers have an obligation, or should have an obligation, to report back to the community at large, and make sure that people are informed about the sort of decisions that are being made, the policy decisions that are being made, obviously not decisions about individuals' licenses. But I believe in transparency, and will work for transparency in the Law Society, and being responsive to people who have questions about the Law Society.
Perfect. So once again, thanks for taking the time to join us here today, and thanks for everyone for tuning in. Take care.
Thank you.